Hi everyone. Today's unit that we'll be doing is equity and trust. And this is the final learning outcome, which is learning outcome 5, which is to understand trustees' administrative powers and duties. Before I carry on with learning outcome 5, I just want to give you a summary of the last learning outcome we did, which is learning outcome 4. In learning outcome 4, we looked at understanding equitable remedies. We looked at the distinction between tracing. So we looked at common law tracing and conditions for the application. We looked at equitable remedies on rescission, specific performance, discretionary injunctions with reference to case law. We also looked at the general nature of equitable remedies, so why they are needed and why courts use them. We also looked at the remedy available only if remedy at law is inadequate. So we looked at the precondition of the award and damages. We also looked at the case of Wilson and Northampton and Banbury Junction Railway Company, 1874. We always looked at, we looked at how equitable remedies are always discretionary and why there's a need for that. We then looked at equity in personam. This was in learning outcome 4. We looked at equitable remedies, so discretionary, prohibitory injunctions. We went on to look at 4.1, which was to evaluate conditions for tracing in law, as I mentioned earlier. And we looked at the 2 types of tracing, which are common law tracing and equitable tracing, and what each one is. We looked at the defences for tracing. We looked at a definition of tracing with reference to the Foskett and McCowan case in regards to tracing. We also looked at tracing in common law in more detail and referred to the case of MCC, Proceeds and Lehman Brothers. We looked at tracing in equity and looked at the case of Boss, Carwin and Bajwa. We looked at the mixture of trust funds with trustees' funds. We looked at 4.2, which was to appraise the application of the change of position defence. And we looked at another defence, which is estoppel, and referred to that with reference to National Westminster Bank plc. We went on to look at 4.3, which is assess when specific performance is one of the most important equitable remedies. We looked at equity acts in persona and looked at the remedy where the remedy is discretionary. We then went on to look at specific performance and how that is important in regards to transactions. We looked at the element of Article 2 of the Uniform Commercial Code in the United States and how that is in regards to the sale of goods and commercial property. So we looked at elements of equity in regards to that, but also looked a little bit at remedies in learning outcome 4. Now in learning outcome 5, we're going to look more at the understanding the trustees' administrative powers and duties, but we'll go on to look at this as the final learning outcome, and then the next discussion will be assignment discussion. So I'll just carry on with that. And this was the diagram that was in learning outcome 4 as well, and it was looking at equitable remedies, which we'll briefly just outline so you have an idea again to refresh your memory in regards to equitable remedies. So just going on to it, just 1 minute. So we looked at equitable remedies, and the first one is rescission in regards to the elements of what rescission is, and it's it can be granted in cases where both parties have committed a mutual mistake that affects the essence of the contract. So there's a mistake by one party that impacts the fairness of the contract and non-mistakenly was aware of the error, and there's a fraud or misrepresentation or undue influence. Rescission is an equitable remedy that effectively cancels a contract and restores the party to their pre-contractual position. So it literally cancels everything and it's all back to the same position again. The next one is specific performance, and this is an equitable remedy that compels a party to perform their contractual obligations as agreed upon. So it could be, for example, a buyer seeking specific performance of a contract for the sale of a rare painting. The painting's unique nature means the monetary damages may not adequately compensate the buyer if the seller breaches the contract. So these are some of the examples in regards to that. And then we've got injunctions. And they're a type of equitable remedy designed to prevent a specific form of harm or any sort of breach of contract from occurring. An injunction is a court order, either requires a party to perform a specific act or reform from performing a specific act, and often is to prevent irreparable harm or protect a legally recognized right. So, you know, you've got prohibitory injunctions and you've got mandatory injunctions, and the prohibitory ones are restrains a party from performing a specific act that would infringe upon the legal rights or interests of the aggrieved party. For example, prohibiting a competitor from using a company's trade secrets. A mandatory injunction is an example is compelling a developer to restore a destroyed natural habitat as a result of illegal construction. And these are both given and granted by the courts. Another one is rectification, and this is an equitable remedy that corrects a written document in order to accurately reflect the true intentions of the aggrieved parties. And this is an example would be where two parties agreed on a 12-month contract term, but due to drafting error, the written contract states a 24-month term. The court can use rectification to correct the mistake and amend the actual, the genuine one, which is 12 months. So the indicative content, so just giving you a brief overview of what we did in the last session, but also an overview of the remedies, and then moving on to the indicative content. So the learning outcome relates to administrative duties that are distinct from fiduciary duties. Powers of advancement, which are conditions and rules governing application. Power of maintenance, which are conditions and rules governing application. Duty of care, the meaning and application. Duty of invest. Trustees Act 2000, Principles of Rational Investments, Defence and Limitation of Liability. So 5.1, explain when power of advancement and maintenance can be utilised by the trustees. So elements of this could be the fact that, you know, trustees have the power to identify certain elements, okay? So the statutory power of advancement is actually, well, what we mentioned is provided in section 32 of the Trustee Act 1925, giving trustees powers to apply capital to or for the benefit of a beneficiary. And section 32 applies to all trustees unless a clause in the trust deed expressly excludes them. So there must be something in the deed that excludes these. This power allows trustees to pay to apply capital for the advancement of benefit of any person who has vested or contingent interest in the capital of trust fund. So previously, this power could only be used to advance up to 1.5 of the beneficiary's interest. However, there's been changes in the Inheritance and Trustee Powers Act 2014, which amended section 32 to remove this limit, allowing this power to advance the whole of the beneficiary's interest. So the amendment made by the Trustees Power Act 2014 only applies to trusts and will trusts created or arising on or after the 1st of October 2014. Section 32 actually doesn't does not apply to discretionary trust. In these types of trust, the beneficiaries do not have an interest in the capital, only the possibility of obtaining an interest. The trustees have a power of appointment and may choose to exercise their discretion in a beneficiary's favour to benefit them. So the power of advancement does not apply to a life tenant of an interest in possession trust who only has an interest in their income. If they are given a separate interest in capital, then the trustee could make advancements in their favour. It's also really important to note that the power of advancement is discretionary power. It's totally up to the trustee's own discretion whether they make an advancement or not, or what terms they make on within the bounds of what the law allows. No beneficiary can compel the trustees to exercise this power in their favour. The advancement of or benefit, so the trustees can advance capital for a beneficiary's advancement benefit. The term advancement refers to both the act of bringing something forward, in this case, the beneficiary's entitlement to capital, as well as the act of somehow advancing the beneficiary's position. And the term advancement was originally thought to be quite narrow and means to advance a beneficiary's life somehow or help them to take a significant step in life. So now we're going to go on to what are the powers of trustees. So, you know, becoming a trustee can be daunting. So for anyone wanting to become a trustee can be a daunting experience, as the trustee will have a range of responsibilities, duties and powers to the trust and its beneficiaries. So as a trustee, you owe duties of honesty, integrity, loyalty and good faith to the beneficiaries of the trust. You must at all times act exclusively in the best interest of the trustees' beneficiaries, must be actively involved in any decisions. So the powers are in regards to investment, dealing with land, delegation of agents, nominees and custodians, insurance, remuneration for professional trustees, advancement of capital, maintenance of minor beneficiaries, and to pay, transfer or lend beneficiaries funds to beneficiaries. So the main four duties of a trust administrator is to filling out tax forms, so to observe the terms of the contract, overseeing any sort of investments, keep beneficiaries informed and protecting beneficiaries' interests. So the four key duties are to observe the terms of the trust. So you must understand the terms of the trust and comply strictly with the duties and directions set out in the trust deed. You must also act impartially between the beneficiaries. So you must not allow beneficiaries to suffer at the expense of another, and must balance the potentially competing interests between beneficiaries for income and capital. You must provide information, as we mentioned. You have a duty to provide clear and accurate accounts, and to exercise reasonable care and ensure distribution of assets. So trust advancement and appointments. This is the trustee's power to advance capital from the trust to beneficiary, to appoint capital. As we mentioned earlier as well, there's two powers to enable beneficiaries to gain access to trust at the time of the amount not provided. A beneficiary that has right to capital, known as vested, has the benefit of statutory power for the advancement of trust to them in Trustee Act Section 32, as we mentioned a little bit earlier. So 5.2 differentiate correctly between fiduciary administrative duties and fiduciary duties. A person, if you're a professional trustee, it can be often overwhelming to comply with far-reaching duties of being a trustee. A fiduciary duty is someone whom another person has placed utmost trust in and confidence to manage and protect their money. And the link on that is on the stakeholder map, which refers to fiduciary duty. The relationship between the trustees and beneficiary is known as a fiduciary relationship and has its core obligation to loyalty, as we mentioned, trust and confidence, with no conflict or no profit rules on part of the trustee. There's also general duty of good faith, which is to act openly and honestly with in regards to their duties, because it's really important in regards to that. The beneficiary is entitled to the trustee's single-minded loyalty. The overarching theme is that trustees are not permitted to use their positions to their own advantage, which in some cases have occurred, and are required to act unselfishly in what they perceive to be the best interest of the beneficiary. So these are some of the fiduciary nature and the fiduciary duties in regards to it. So trustees must comply and abide with basic rules. Okay, so there are basic rules. They must have only act in the interest of the beneficiary as a whole. They must do not try to put themselves in a position where their personal interest conflicts, because that's really important, or where there's really a possibility of conflict with the fiduciary duties or the beneficiary's interests. They must not adversely affect the beneficiary's interests. They must subordinate any personal interests they have to that of the beneficiaries. They must not favour one beneficiary over another, and they, without authority, make a profit from the use, or to not make a profit from their role, because it's really important when we talk about fiduciary duties. Why is it important in regards to trying to not make a profit out of this? And a really important case which established this was the case of Kelly and Anor and Baker and Anor 2022, where the court considered that the hallmark of cases where fiduciary duty has been recognised in the absence of express undertaking is legitimate expectation. That could arise from the parties' historical relationship or from particular representation or dealings. In either cases, the question is not whether a party believed it could repose the relevant level of trust in the other, but whether it was objectively entitled to do so in all circumstances. The existence of close personal relationship may make it more likely that such a legitimate expectation could arise, but the circumstance is not determinative and does not itself give rise to the duty. In the present case, two individuals had worked in and for a family business empire for many years and were held not to have owned fiduciary duties to the family members when leading a management buyout of the part of the business. A level of informality in the running of the business may have fed the claimant's subjective perception that there was a special relationship of trust and influence, but that was not the objective reality. The decision illustrated that while fiduciary duties can conceptually arise in any context where there's a necessary special relationship of trust and influence, claimants face a high bar in establishing the factual foundation. And another case in regards to fiduciary duties was the case of Bristol and West Building Society and Morphew 1998, that in this case that a fiduciary is someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which gave rise to a relationship of trust and confidence. The circumstances here did not fall into any of the well-established categories of relationship that had been recognised as involving an undertaking, such as director or a company relationship. It was common ground that the fiduciary duties could arise outside those relationships and need not include an explicit undertaking to act or for or on behalf of the other. So these are some of the cases and these are some of the duties of the trustees in regard to their fiduciary duties. Trustees' duties and liabilities. So the trustee manages the trust's assets, a significant responsibility. The trustee is either appointed by the settlor or the court. If the settlor failed to appoint someone, or if the appointment trustees fail, the trustee must voluntarily accept his or her position. Once accepted, the trustee cannot resign without the consent of all of the beneficiaries of the court or the court. A trust will not fail for want of a trustee. Since the trustee holds legal title to the trust property, he or she owes fiduciary duty to the beneficiaries, as we mentioned earlier, who have the equitable right. The trustee must demonstrate the property in accordance with the settlor's instructions and desires. His or her three primary jobs include investment, administration, and distribution. A trustee is personally liable for a breach of his or her fiduciary duties, and the trustee fiduciary duty include, as we mentioned earlier, duty of loyalty, prudence, and subsidiary duties. The duty of loyalty requires that the trustee is held an objective standard of care in managing the trustee's property. Subsidiary rules include the duty of impartiality and the duty to inform and account the beneficiaries. So again, looking at the beneficiaries' duties, fiduciary duties of good faith. This was in the case which I mentioned of Bristol and West Mohi, and what was identified in that. Why have fiduciary duties? Fiduciary duties act as a problematic. They are to prevent conduct of part of the fiduciary and to prevent unwanted conduct. Some arise from statute, others from common law. Essentially, fiduciary duties may not personally profit from his position and has, number two, overriding duty to avoid a conflict between his personal interests and the duties that he owes to his principal. And this we looked at in the diagram, which identified the fiduciary duties are no profit, no conflict rules in an act of good faith. Trustee equals placed by settlor that they receive from settlor who held in beneficiary person in whom absolute ownership will reside. The owner's duty is imposed on you as a trustee. So primary duty, carry out the terms of the trust. Stewardship of the trust is safeguard the trust assets. Act unanimously, act in good faith. Bookkeeping, be even-handed, impartial, and duty to invest. Obligation to distribute property and not to delegate. Be adequately informed before exercising their duties, as in the case of Pitt and Hull, where the fiduciary duties meant all equitable duties of trustees, not exclusively fiduciary duties identified by Lord Chief Justice in the case of Lord Chief Miller in the case of Bristol and West and Morphew, which we had a look at earlier. Otherwise, breach of trust and personally liable. Duties imposed on trustees and other fiduciaries equal fiduciary duties don't just apply to trustees. Two roles of managerial and distributory role, but anyone in a fiduciary relationship. So it could be a solicitor, it could be an agent to principal, business partner to a co-partner, company director, an employee, or any other position. So fiduciary nature of certain relationships. And these are some cases that in regards to that. So equity can also find a fiduciary duty to arise in other circumstances, where a person has undertaken an act for or on behalf of another in particular matter in circumstances which gave rise to a relationship of trust, as in the case of Bristol and West Building Society and Morphew. Thus, whilst distinguishing feature of a fiduciary relationship is Miller's single-minded duty of loyalty covering the no profit, no conflict rules, the exact content of particular fiduciary relationships will vary from duties owed by trustees than by company directors. And the case in regards to that is, first case is Reading and Attorney General, where the British Army sergeant bribed by Egyptians to help pass checkpoints held in fiduciary relationship with the Crown and liable to account for his bribe to the Crown. The other one is Attorney General for Hong Kong and Reed. DPP accepted bribes and used money to purchase properties in New Zealand. It was held that money received in breach of fiduciary duty to the Crown and properties on constructive trust for Crown. Previous counsel rejected argument, Crown only entitled to personal claim for money. And then Attorney General Guardian, Sunday Times liable to account to Crown for profits made by publishing Spycatcher and the book written by former Secret Services in breach of fiduciary duty by the Crown. The final case is CF and Blake, former member of security services, who disclosed information in book, didn't owe fiduciary duty to the Crown, as info was no longer confidential, but ordered to pay profits from book as damages for breach of contract with the Crown, not to disclose information without consent, whereas usually only ordered as a remedy for breach. Recent case where a fiduciary duty was found in context of joint nature venture was Murad against Al-Sarraj, where it was persuaded to own others into JV to buy hotel, but fraudulently representing to them he would contribute 500k in cash to purchase. His contribution was setting off a secret commission that the hotel vendor agreed to pay him. It was held that fiduciary relationship between him and two others in relation to JV, as they repose trust and confidence in him by virtue of their relative position. Usually, fiduciary duty imposed where there is a pre-arranged relationship of trust, confidence, where one party expected to act in interest of another. The court went further and imposed fiduciary duty as an artificial remedial device to correct injustice. C paid 1 million to D Bank by mistake, held by virtue of mistaken payment, with D Bank had a fiduciary duty to C Bank and held money on constructive trust for them. C thus retained an equitable proprietary interest in the money and entitled to make a tracing claim to it on D's insolvency. The remuneration charge in regards to this are that trustees not entitled to make personal profit from their position, as in the case of Bray and Ford. They must account to the trust for their profit, they must pay it back or hold assets. They're not allowed to put himself in a position where the interest and duty conflict. Also, rule apply to a solicitor-trustee relationship where they looked at is the case of R. Gates. Another one is quite a recent case in regards to the trustee and the solicitor and trustee relationship is in the case of Lucas and Gilbert 2022, where solicitor and his client entered into a joint venture in respect of the development of a property, by which the solicitor provided the purchase costs and the client agreed to develop the property. The parties agreed to mutually share in the profit generated. The agreement was not reduced to writing. The parties subsequently fell into dispute as what was agreed and whether the agreement was vitiating by alleged breaches of the fiduciary duty or alleged undue influence. These were the basic facts. The trial took place before Sanderson, Lord Justice. The judge held that the claimant's case on the agreement was correct. The parties had agreed that solicitor would be entitled to 50% shareholding in the property owning company. In so holding, the judge referred and applied a well-known guidance in the case of Guestmin 2013 as to the correct approach to witness evidence, in particular where there are gaps in documentary evidence. Of more general interest were the judge's observation as to whether the agreement was vitiated by alleged breaches of fiduciary duty and alleged undue influence. The basis of these arguments was that the agreement was unenforceable by reasons of the solicitor's fiduciary position, which it said prevented him from profiting under the agreement, and B meant that the agreement had been entered into by reason of undue influence. The judge robustly rejected by the defendant's argument as to the fiduciary duties, citing academic and case law authority for the principled proposition that the scope of fiduciary duty is moulded according to the nature of the relationship and the facts of the case, and the court must be careful not to distort the contractual agreement arrived at between commercially contracted parties by fiduciary obligations inconsistent with the contractual bargain. On the facts, the agreement was outside the scope of fiduciary duties between the solicitor and client. The judge also dismissed the suggestion that the agreement was entered into by undue influence, so no presumption of which arose because the transaction could readily be accounted for by ordinary motives The decision is therefore salient exemplar of the application of principles applicable whenever a fiduciary duty and a principal entered into a contractual relationship. 5.3, evaluate trustees' defences for breach of administrative duties. So trustees are jointly and severely liable for breach of trust to their beneficiaries where the breach has led to a loss of trust fund. Common allegations of breach of trust include where they distribute trust assets to a beneficiary who is not entitled to them under the terms of a trust document. They invest the trust fund in a way not permitted by his express or statutory powers of investment. And the next one is breaches of fiduciary duty, such as the duty not to profit from the trust, or breaches the common law or statutory duty of care, for example, by exercising the power of investment without exercising such skill and care as unreasonable in the circumstances. So trustees are jointly liable, and the breaches invest, they have to make sure that they are meeting the fiduciary duty requirements. The defense is available. So the first one is exemption clause. And a trustee who has committed a breach of trust could be protected from a breach of trust by an exemption clause in the trust deed. However, if the exemption clause, trustees still have a minimum duty to perform the trust honestly and in good faith for the benefit of the beneficiaries. And an exemption clause cannot excuse a trustee who either knows that his act or omission is contrary to the beneficiary's interests or is recklessly indifferent to the beneficiary's interests. The next one is limitation, which is if a trustee is not protected by an exemption clause, he or she could escape liability if the claim is barred. It has been long established law that in general wrongdoers ought not to be subjected to threat of legal proceedings for an indeterminate period after the occurrence of events to which they relate. The Limitation Act 1980 sets out periods which specify a statutory time limit which the legal proceedings of a particular kind must be brought. Limitation serves as a defence to a claim and must be pleaded as such. With regards to breach of trust claim, the starting point is 6 years from the day in which the right of action occurred. For example, the date of breach. And the case in regards to that is the case of Armitage and Nurse, 1998. The 6-year time limit is, however, subject to Section 21, subsection 1 of the Limitations Act 1980, which provides there is no limitation period in respect of fraud or fraudulent breach of trust in regards or to recover the property. So fraud of these purposes means actual dishonesty, as in the case of Armitage and Nurse, 1999. In this case, the key point was the trustee exemption of liability clauses are valid insofar as they exclude liability for negligence, but not actual fraud. Good faith and honesty are irreducible trustees' obligation. The facts of the case of the plaintiff became entitled in remainder to agricultural land of which her mother was tenant for life. The plaintiff was 17 at the time. Her position was to be held on trust until she reached 40. The value of the land fell unexpectedly and the trustees had failed to supervise or inquire as to why their value had fallen. Clause 15 of the trust deed stated that no trustee shall be liable for loss or damage to the fund income unless caused by actual fraud. P brought an action for breach of trust. It was held in the Court of Appeal that clause 15 operated to exclude trustees' liability for negligence, and the appeal was dismissed. The next one is Latches, which is delay. So even where there's limitation, no limitation, period applies because the claim is one of fraud. The trustee may have a defence of latches under the equitable doctrine of latches. If there's unreasonable delay on part of the claimant in pursuing the claim and the trustee's position has been prejudiced by that delay, the courts may not permit the claim to proceed. The next one is consent of beneficiaries, and it is also a defence to claim for breach of trust if the claimant beneficiary consented to or concurred with the breach. However, there are a number of conditions. So firstly, that the beneficiary must have been at full age and capacity. Secondly, that the beneficiary must have freely given consent to be free of undue influence. Thirdly, that the beneficiary must have given an informed consent. Fourthly, it is necessary that the consenting beneficiary has benefited from the trust of, although they may be significant, as in the case of Fletcher and Collis, 1905. The statutory relief under the Trustee Act 1925 and section 61 is the one we'll be looking at in regards to this. The section 61 gives the power to the court and to relieve a trustee from personal liability for any breach when it acted dishonestly and reasonable, acted honestly and reasonable, and ought to be fairly excused. So the court can relieve, as we mentioned, relieve a trustee if they reasonably are found to be fairly or honest. The beneficiary consent is a defence for a breach of a trustee of full age and capacity not to be subjected to undue influence. If the trustee is found to be acted in breach of a trust, they are required to restore the trust fund to the position it would be in before the breach. So, there are limitations in place in regards to section 61. The relief is also given when the trustee has been found to be in breach of the contract, and the court then has to consider exercising discretion. Even if the trustee has acted in an honest and reasonable way, the court may not exercise its discretion, particularly if the trustee is a professional, has been paid for his service. So, it would be based on each circumstances of each case, because if it's someone who's been paid, like a solicitor in his professional circumstances, and he's, acted dishonestly, then, the courts may be quite hesitant to offer any sort of elements of, any sort of protection in that instance, because they'd be identifying any sort of issues around that. There may be issues in regards to any sort of property in that faith, and that's the case of R.E. Holding Settlement Trust 1964. As a result, private individuals act as unpaid trustees and generally more likely to find themselves excused under the provision, but whether the discretion will be exercised ultimately turns on the facts of each individual case. So each individual case is based on the severity of each individual case. It is important to know that section will not apply to if the trustee has been negligent in practice. This means that a trustee cannot be found to have acted reasonably if he failed to obtain the level of skilled advice necessary to the size of trust. The next one is Section 62 of the Trustees Act in regards to the breach of trustees' duty and how that can be applied. So Section 62 is where a trustee commits a breach of the request, where a trustee commits a breach of the request in writing of the beneficiary. The court has discretion to use beneficiaries' interests in the trust to identify the trustee who's committed a breach. Under Section 62, it's not necessary to show that the beneficiary actually benefited the actual benefited from the breach. So it's important to identify that and to identify the elements of Section 62 in regards to breach, because if a trustee breaches his duties, it's really important that it's all highlighted, and it's really important that conveyancer take this into board as well when it looks at breaching it. Section 62 in regards to that was the case of Weldon and Burroughs, 1879, in regards to Section 62. So if you want to have a look at that case in your own time, it's quite an important case to look at. But it's so important in regards to breach of properties, that breach of trustees' duties, that we bear in mind that, we don't breach the duties. Trustees are obliged to act together, and they are advised to act in the best interest of the beneficiary. So a trustee has rights that they must follow. If they don't follow their rights, then they've breached the rights. They have a duty to act within that. So you as a trustee need to make sure that you are acting in the you're not breaching any sort of duties or breaching your fiduciary duties, because that in itself is an element of where it is a failure to do that would result in a court order, or you having to pay back your own funds, or having to pay back the fact that you've breached the trust of the beneficiaries, where you have a duty, and you have a standard of care under Section 1 of the Trustee Act 2000, that you must have special knowledge and experience of this. And we've looked at the breaches and the elements of defences and damages available, and things like beneficiary consent, limitation, delay, and if a trustee is found to be acting in breach of the trust, they're required to restore, as we mentioned, the funds. So it's your responsibility as a trustee to follow the fiduciary duties, and if you breach them, you have a duty of care, and you must make sure that that there are defences available, and that you could get into some form of trouble if you don't follow your fiduciary duties. So we've finished looking at Section 62 of the Trustee Act 1925. Some of the references we've used for today's session, which is Learning Outcome 5, and this is the final session. So tomorrow we'll go through the assignment discussion, summarise Learning Outcome 1, 2, 3, and 4, and then and 5, sorry, as well, and then we'll go on to the assignment discussion. These are some of the resources used for Learning Outcome 5, which we've done today on fiduciary duties, remedies, breaching fiduciary duties, Section 61, Section 62, trustees' rights and obligations to the beneficiary, and we've looked at elements of, the importance of the cases that have been used where the solicitors or has breached the fiduciary duty with the client, and how that impacted on it, and why it's so important that we follow our duties and what constitutes breach as well. We looked at that. So you could go on to these links here, and you could, if you right click them, you could get resources on them and have a read around Learning Outcome 5. This is the end of today's session. The next session is assignment discussion, and thank you for attending today's session. I will see you in the next session.